Welcome to The Explainer. Today we're tackling a question that comes up all the time in law. What happens when you need to change your court documents after you've already filed them? We're going to break down Rule 26 of Ontario's Rules of Civil Procedure and give you a clear step-by-step guide. Okay, let's just dive right in. Picture this. You filed your statement of claim, you've sent it off, and then you spot it. A typo, a factual error, or maybe you uncover a new piece of evidence that changes everything. Is it too late? Are you stuck with that original flawed document? Well, the answer, thankfully, is a resounding no.
All right, so first things first, let's get on the same page with a key term here, pleadings. When we say that, we're talking about the core, formal documents that lay out each side's case. You know, the big ones, the statement of claim, the statement of defense. They're basically the foundational blueprints for the entire lawsuit.
See, at the heart of this entire process is a really fundamental principle of our justice system. The main goal is always to get to the real issues between people, to solve the actual dispute, not to get hung up on technical slip-ups made early in the game.
And here it is. This is where the rule shows its real muscle. Look at that word, shall. Rule 26.01 says the court shall grant leave to amend. That's not a maybe, it's not a suggestion. It is the default position. The court wants to see justice done based on the facts, and allowing corrections is a huge part of making that happen.
Now, this brings us to the one major catch, the one big exception, prejudice. The court will only say no to an amendment if it creates an unfair disadvantage for the other party that you just can't fix. For instance, if you wait until the last minute and the other side can no longer find evidence to respond to your new claim, that might be prejudice. But if the problem can be solved with a bit more time, or by having you pay their legal costs for the trouble, the amendment is almost always going to be allowed.
Okay, so this all leads you to your first big question. You know you need to make a change to your pleading, but do you actually need to ask the court for permission? Well, the answer really boils down to timing.
So Rule 26.02 basically gives you two different paths. Think of one as the express lane. If you act early, before the pleadings are considered closed, you get one free pass to amend your document, no questions asked. The other path is for when you're a bit later to the party. That's when you either need to get everyone else to agree in writing, or if they won't, you have to go to the court and get a formal order.
So you've figured out if you need permission. Great, but now for the practical part. How do you actually make the change on paper? The rules are super specific about the nuts and bolts here. And for a very good reason, to make sure there's absolutely no confusion for anyone. Rule 26-03 gives us this really clear four-step process. You don't just sneak in a new document. You physically modify the original copy, and, this is critical, you have to underline every single word of new text. This makes it instantly obvious to everyone what's been changed. The court registrar then adds a little note explaining why and when the amendment was made. And hey, if you've made a ton of changes and the document is starting to look like a mess, you file a fresh, clean version to make life easier for everyone. And here's a fantastic little procedural tidbit for you. If you have to amend that same document a second time, the new changes get a double underline. A third time, you guessed it, a triple underline. It's a simple, elegant visual system to track the entire history of the document's evolution, right there on the page.
Awesome. You've successfully amended your document. But wait, you are not done yet. It is absolutely crucial that every single person involved in the case is officially notified of the changes you've made. You've got to close the loop. Rule 26.04 is crystal clear. You have to serve that amended pleading forthwith, which is lawyer speak for right away, don't delay. And when it says serve everyone, it means everyone. It doesn't matter if they're part of a counterclaim or a third-party claim. If they are a party to the overall action, they get a copy. This ensures no one is operating with an old playbook.
Now, here's a super important warning. Let's say one party has been totally ignoring the lawsuit and has been noted in default. You can't just ignore them back. If your amendment substantially changes the case against them, Rule 2604 says you still have to serve them personally. This protects their right to be told if the whole game is changed. Okay, so you've served your amended document. This action, of course, triggers a reaction. Once the other parties get your updated paperwork, the rules give them a fair shot to respond to the new claims or facts you've just put on the table. And according to Rule 2605, the timeline for that response is designed to be fair. The other party gets whichever period is longer, either the time they had left on the clock to respond to the original document or a fresh 10 days. This makes sure no one gets sandbagged by a last-minute amendment. So what if they just do nothing? Does the whole case grind to a halt? Nope. The system has a really smart and efficient fix for that. If a party doesn't file a new response, the law simply says they are deemed to rely on their original one. This prevents the whole process from getting stalled just because someone doesn't want to refile a document that they feel is still perfectly fine.
We've gone through all the mechanics, right? The how of amending a pleading. But let's just zoom out for a second and think about the bigger question. Why? Why does the legal system have such a detailed process for something as seemingly simple as correcting a document?
Well, at its core, Rule 26 is really a tool for justice. It recognizes that lawsuits are living, breathing things. Facts get uncovered, strategies change, and hey, people make mistakes. This rule provides that essential flexibility to make sure a final judgment is based on the most complete and accurate story, not on who happened to draft the best document on day one.
And this really gets right to the heart of it all. Just think about that for a moment. A single, new fact, added to a case through a timely amendment, could be the one thing that separates winning from losing. Rule 26 isn't just some dry procedural rule, it's the very mechanism that allows a case to adapt to the truth as it's discovered. It ensures that in the end, the full story can actually be told.